Welcome back to the Environmental Law Monitor. I'm your host, Daniel Pope. This podcast is brought to you by Bracewell LLP's Environment, Lands, and Resources Practice Group, and it's a place for thoughtful conversations on environmental and natural resources law and policy, ranging from the latest developments to perennial topics like litigation, enforcement, and compliance assurance. We're glad you're spending some time with us today. All right, fall is here-ish in Texas. If you wake up early enough and go outside, you might feel a little bit of the crispness. I always look forward to the fall, not just for the weather change, but because the Supreme Court's back in session. This year, we have midterm elections. We'll be talking about all of that and more on this podcast as we go through the fall. We also have our practice group's environmental law seminar on November the 15th in Houston. If you're a client, you should have received a save the date for that, but reach out to us if you've not. We'd love to provide you information on that. Today, we're going to be talking about the treatment of environmental claims in bankruptcy proceedings, the before, during, and after of a bankruptcy. But before I introduce our guests, I want to give this disclaimer. I'm tweaking a disclaimer of my father-in-law. He's a wills and estates attorney, and every time he prepares a will for somebody, his clients start treating him like he's the angel of death, and that by finalizing a will, he's somehow shortened their lifespan. So he gives them this disclaimer saying, I'm not the angel of death. You've done a great thing in preparing your will, and you're going to have a long life. The Lord bless you and keep you and so forth. And as we talk about bankruptcy today for all of our listeners, I want to, disclaim that just by listening to this podcast, you are not about to enter a personal bankruptcy. The company that you work for is not going to enter a bankruptcy. We wish you financial success and security. And so with that disclaimer out of the way, I hope you're still with us. I want to introduce a couple of our guests. First, we're joined again by fan favorite, chair of the practice group, Jason Hutt out of Washington, D.C. And we're joined by a new colleague of ours, Stephen Cook, who is joining us most recently from EPA's Office of Land and Emergency Management. So welcome to you both. Thank you for joining us.
Thanks for having us.
Thanks, Daniel. Pleasure to be here.
So we're going to be talking about Chapter 11 bankruptcy today, the reorganization form of bankruptcy. And we're going to be talking about how a variety of environmental claims and a variety of environmental requirements are treated and managed throughout the bankruptcy process. And so, Stephen, I'd like to go to you, and given your significant in-house experience, would love to hear from you about the kinds of considerations in-house environmental counsel have when they are looking at an impending bankruptcy, entering into that bankruptcy and the very first stages of the bankruptcy to ensure that the company continues to comply with environmental requirements, that the company is considering and evaluating and assessing the scope of its environmental liabilities. What does that look like from those early days of a bankruptcy?
Well, from my time at LyondellBasell, when we went through the Chapter 11, it's actually a fascinating time if you are able to step back and just watch, because it's a very different legal environment that you're operating in, but your core compliance obligations are still there. And as you get close to the bankruptcy, folks are not blind to what's going on. They see the struggles, and keeping people focused on ensuring you're complying with your environmental obligations. The rules apply before you file and when you file and after you file. So you still have to operate in compliance. And when people are distracted by whether they're going to have a job, whether their plant's going to stay open, such, it's very easy to lose that focus. So one of your roles as in-house counsel is you've got to stay focused, despite what's going on with your personal situation, to really ensure everybody is continuing to make sure the wastewater is properly treated, samples are being taken, you're meeting all those day-to-day routines and such. But it's quite a psychological impact on folks. We at Lyondell actually had a couple of lawyers who had gone through the Enron bankruptcy, and they left us shortly after we filed. They didn't want to go through it again. It's a very emotional, draining process on you. But you got to stay focused on making sure you keep following through on your compliance obligations.
And I suspect you're being asked to do more with less, right? You're being asked to think about what capital expenditures you can defer, and your staff is getting leaner along the course of that path, and staying focused is challenged because of that.
Absolutely. And you've got to stand firm that if there are expenditures that are in place that are needed to be in compliance, that those are part of what needs to continue on and not be sacrificed as you look to scale down and deal with the various obligations.
That probably involves making a case to management that certain divisions, certain personnel, certain capital expenses are necessary for maintaining that compliance status. It
can. It really depends on, every bankruptcy is different into why you came in. Some go in because their liabilities are just, and they might be contingent liabilities, future claims, like the former asbestos manufacturers. Mm-hmm. It was really liabilities, but their cash flow was fine on day-to-day operations. In other cases, you're running out of cash and you can't meet payroll. And so it's the day-to-day expenses that are out of whack, and you're trying to address those. So there's both, your operating side and your financial sides. Either one can put you into bankruptcy, or in some cases, both are out of whack and you've got to deal with them. But regardless of why you're in, you still make sure that you are complying with the law.
And unlike your father-in-law's clients, Daniel, the bankruptcy is a Chapter 11 bankruptcy is an opportunity for a fresh start, right?
That's right.
If you can wash through the process, right? The bankruptcy, the debtor wants to move through the bankruptcy quickly and reorganize its financial obligations to get that fresh start. And that means there's like this short period of time where you can adjudicate the claims and establish the amounts and deal with the creditors. But on the back end, there is this fresh start. Environmental law sort of doesn't quite line up with that. So there's a tension between the two, right? Environmental law is taking at least site condition liabilities and allowing you, if you can manage that over a period of time, to move that down the road, so long as those conditions don't pose a threat to human health or the environment, right? That contamination is not leaving the site. And you may not, in a present day, agree upon what that liability is and a net present value. And so that makes it difficult to bring through the bankruptcy process. But bankruptcy fundamentally is giving a Chapter 11 bankruptcy is giving a company a fresh start. It's how you get yourself into that process and what happens when you come out that is the challenge that Stephen's lived through.
Yeah, and when I taught this class at the University of Houston Law Center, I called it the Clash of the Titans. Bankruptcy is very powerful. The law there, to get to the fresh start. But as are the environmental law, and their requirements are also very powerful. And frequently you have a clash between them as you go through this process and resolving the various liabilities.
So let's talk about that clash here in a second. But before we do, I'm curious about what you do to sufficiently map out what those environmental liabilities are, where they're coming from, and how you begin the process of wrapping your arms around all of the things you could potentially wash through bankruptcy to get that fresh start, to make sure that you are taking full advantage of that process.
The current claims are easy, the current lawsuits, disputes with agencies and such. It's the trying to expand to the potential future claims. Take potential Superfund sites or existing sites for which you are involved. And you want to catalog every potential site that you might be involved in, that you think you might have. And because your goal here is to give notice to anybody who might have a claim that you filed, and that they've got the information to know when to file and such, so that when you get out on the other side, you've got an effective defense that, hey, they knew they had a claim, they were given notice that we had filed, that they needed to file. And if they didn't, too bad. Or if they did, it got resolved. So there's a lot of work in making sure you've thought through all the places where your waste may have ended up, or all the potential claims as you think about the environmental aspects of your operations, who might have a claim against you for what you've done. And there's some interesting things about, whether it's talking about the greenhouse gases or PFAS and such, that are starting to percolate as claims, but are they ripe enough for bankruptcy to effectively deal with them now?
So let's go off of that and think about what types of claims, or discuss what types of claims can be discharged or effectively treated through that bankruptcy proceeding. Let's start off with response and cleanup obligations. How are those managed? How can companies effectively discharge those types of claims? Especially when, Stephen, you mentioned that you have visibility into some of those claims, but then, a lot of times, a lot of sites, you're still in the process of investigating the extent of contamination in soils or groundwater. So what do you do about the knowns, and what do you do about the unknowns, and how are those treated in bankruptcy?
Oh, part of it really lies on what your plan is. Are you planning to keep that particular site going forward? If your exit plan is going to be these 10 manufacturing sites, we want it, they're part of the ongoing business. Well, all the contamination that's there and such is going to stay with you and pass through. But if you're abandoning the property or walking away from it and such, there are ways to effectively get that liability resolved and discharged and be done with it.
I think the word to substitute between unknown and unknown is coet and inchoate, because that's the bankruptcy vernacular that the courts are going to use to determine which pre-petition environmental obligations are subject to discharge. And then Stephen's pointing out, the way I think about it is, well, if I'm going to be the owner operator of the facility after bankruptcy, then the benefits of the bankruptcy discharging the liability associated with prior ownership and operation really isn't going to inure to my benefit, because I'm stepping into the net of liability on day one post effective date of the bankruptcy. But the bankruptcy itself can only discharge the liabilities that are coet, and then that's known, that's manifested. It has a fiscal focus, right? Is there a monetary obligation as to a claim? Is a cleanup obligation, a claim because it satisfies the fair contemplation test, or is there a pre-petition relationship theory that you can discharge it because there was a contract, or because there was an exposure, or there was an impact, or there was some sort of privity that existed between you and the party that would make that claim against you post-petition. And those are the kinds of things that if you effectively give the notice that Stephen's outlined, prior to the bar date, that you can say, okay, well, you had this relationship with the debtor, and the debtor put you on notice that your claim was going to be addressed through the bankruptcy process. Now the debtor has been scrubbed of that liability for purposes of going forward. There are a lot of things that fall into the gray area, notwithstanding the clarity that hopefully I've said that with, but that's the framework that you have to then confront environmental liabilities and try to figure out which of them can you effectively wash out through the bankruptcy process and which can't you. And some of that is going to depend on what are you going to do with the assets going forward. If you're in a Chapter 11, either you're thinking of reorganizing and emerging, or you're thinking that you're going to use that process to abandon some of the properties or sell some of the properties through the bankruptcy process. And so, it depends on the strategy that you're trying to implement as to where you're going to place priorities. And I should mention one other thing, which is that there's the concept of administrative expenses in bankruptcy, right? So there are $100 that you're going to spend during the period of bankruptcy, and those dollars can be spent to comply with law. That's pretty clear in all the jurisdictions. And so if there are things that you need to do to be sure you're bringing your operations into compliance, those are things that you can contemplate and address through the courts to spend that money to be in compliance with law. Now, there are some things at the margins as to what is within the contemplation of complying with law, including whether you have to pay fines or penalties, and there are differences in the courts about whether that's an administrative expense or not. But each of those are considerations as you outline the strategy of how you bring a debtor through a Chapter 11 process.
And you mentioned jurisdiction, and it's important. There's not a uniform application of some of these gray areas in the different circuits. And so what are the key liabilities that are driving you to the bankruptcy may dictate where, if you've got an option of which form you want to file in, to think about. But as to the environmental aspects, it's one of the few times in my career that I actually had a little leverage over the United States government. Normally you don't. But as you're putting together your plan and start heading towards getting out, if there are significant claims that the U.S. government has and you're dealing with, and in my experience, we had billions of dollars of Superfund claims, and the government had a lot in there, and it made a lot of claims. But as they see the plan coming together, there's going to be pressure on the government to agree to the plan. Most judges seem to want, if you're in an 11, to get you off the operating table and back out there. And I tell you, being bankrupt is very expensive. Those administrative expensive. In our case, my back of the envelope calculation is we were probably spending about $1.5 million to $2 million a day for the privilege of being in Chapter 11. It was 20% interest money, the debtor in possession financing, and all the fees. You're paying for everybody's lawyer, and there's a lot of them when you go up to those hearings and such. So it was just incredible. how expensive it was to be bankrupt during that process. But as the government sees the plan coming together, they're going to get pressure from the court to settle. Bankruptcy judges really like you to settle, resolve things so they don't have to deal with it. Because if they've got to see it, you take a major Superfund site, say you're cleaning up a river that could be anywhere from $1 to $3 or $5 billion or something. You may get one day in which to fight before the judge is the valuation of that claim, and then the decision comes. So what in typical Superfund world would be a 10 to 20 year process will be a one-day hearing potentially in bankruptcy if you don't resolve. So there's a lot of pressure to come up with a pragmatic solution that everybody, can live with. They may not like it, but it helps you move out. And that's really the goal in 11 is you're trying to get out so that you can become back out on your feet and go and have everything resolved. And everybody knows what's resolved and what's not. So that trying to reach that clarity does give you a little leverage with the government because they'll be pressured by the bankruptcy court to try to resolve things. In fact, I had one hearing, share with you. It was scheduled for Monday afternoon, and our lead bankruptcy lawyer came in and said, have you settled this yet? No. So the clerk was calling to just check on that. And he comes back in 30 minutes later and says, your hearing's now Tuesday. He'd really like you to settle. And so we met again and still hadn't resolved. So Tuesday morning, he comes and checks. Have you settled? No. Clerk calls. Your hearing's now Wednesday. He really wants you to settle. So we finally got the hen. And, we spent a lot of hours, late nights. And finally, before the Thursday hearing date, we had finally reached a settlement. So he took it off. But that's kind of the pragmatic things that'll happen. And this was involving, 3 different private entities and all sorts of environmental claims from abandoning, one of the fascinating questions, can you abandon a chemical plant that is sitting on leased land that you don't want anymore? It's sitting on leased land. It's not your property. You've rejected the lease. What do you do with the chemical plant that happens to be sitting on top of it?
I didn't do the chemical plant case, but in an upstream oil and gas case where we wanted to abandon a lease on a public entity's land, the well was plugged and temporarily abandoned, and the public entity did not want us to leave them the keys, although we'd come to them beforehand and let them know that we were going to go into the bankruptcy and that they ought to line up a contractor to oversight the permanent abandonment of the well. And they wanted to take us to a hearing on the fact that the cost of maintaining the well in its abandoned condition should be an administrative cost to comply with law. And we said that it shouldn't. It didn't pose any threat to the environment. It was in a static state. And, apropos what Stephen was saying, I think we had a hearing one week, and the next week we were back in the Delaware courts, and I did the deposition starting at 7:00 in the morning so that we could be ready for a hearing at 1:00. So the deposition occurred in the morning and the hearing on the matter. We took the witness testimony at 1:00 that afternoon. And that's how fast things go down in the bankruptcy court. It is a much more expeditious process to bring the debtor through. And so these environmental issues get resolved in many different ways. And then it gets even more interesting when the liability at issue is not a contamination concern or a land concern. If you're dealing with, I would sort of broadly call it environmental attributes, right? Like if you look at the Philadelphia Energy Solutions bankruptcy, where literally it was the RFS program that dragged them into the bankruptcy, but there had to be a compromise between EPA and PES in order for that matter to resolve itself. And the bankruptcy courts forced that process of resolution in a different leverage dynamic, as Stephen referred to, than one normally encounters when working across from the agencies.
Jason, do you want to expand on that? You're talking about environmental attributes, and you mentioned the RFS program. I think what you're talking about there is that you've got environmental conditions, but then you also have environmental attributes connected with a product or a facility. So you're talking about the RFS program and renewable identification numbers, but you could also be talking about RECs, right? Renewable energy credits or any other kind of attribute or credit that's spun out of something material.
In the environmental law world, we have come to separate the environmental attribute from the physical aspect of something, right? Whether that's the generation of carbon dioxide or the creation of an electron that has a green attribute, or whether it's green hydrogen or blue hydrogen, whether it's a production tax credit or a RIN. I mean, each of these things were created to drive market dynamics to favor the more environmentally friendly way of making something, whether that's producing electricity or creating a fuel. Biofuels is another example. But in many of those cases, the legal obligations associated with the environmental attribute are timed differently from the creation of the underlying physical thing, right? So if you look at renewable fuels, or if you look at the CO2 program in California, the La Paloma bankruptcy, where they had the generation of power gave rise to surrender obligations for carbon credits, carbon offset credits. But the surrender obligation was at a different point in time than when the power was generated. And the bankruptcy occurred between those two events. And so the parties got into a fight in the bankruptcy court over whether or not the surrender obligation was something that the debtor had to satisfy, or that the post-emerging debtor, the new company had to satisfy. If the surrender obligation came up after the bankruptcy, but the generation of the power occurred before the bankruptcy, who has the surrender obligation? And California took the position, unsurprisingly, that if you didn't maintain the integrity of that program, you would essentially be lifting the cap, right? You have a cap and trade program. And if someone can emit and then go into bankruptcy and then not be required to surrender the carbon equivalency obligation, then the cap is not doing what it was supposed to do. And so the market breaks down. But that's not the way bankruptcy law contemplates it. So it was an interesting case. In that circumstance, I don't think the carbon equivalency obligations were driving the bankruptcy, whereas in the Philadelphia Energy Solutions case, it was driving the bankruptcy. I mean, if you read the first day declaration, that is why they were seeking the Chapter 11 protections. And you can juxtapose that with, Stephen talked about chemical plants. We just saw, because of oil and gas, the dip in oil and gas prices during pandemic, you saw what happened to Fieldwood in the offshore world, where you had enormous decommissioning obligations, which aren't necessarily co-it in the sense that they exist on the day of the bankruptcy, but you have a whole set of financial assurance mechanisms that have been set up to deal with circumstances where the party responsible for performing the ultimate environmental remediation or decommissioning of those assets is no longer solvent. And so all of the predecessor owners are called onto the mat, as well as all of the people who issued the financial assurance instruments over the course of time. And that's when the fights happen in the bankruptcy courts.
And that gets to the point where as you think about your notices and such, make sure you give notice to all those types of parties and all those types of events to bring them in. And a fascinating part about the bankruptcy, as I kind of thought of it, is if you think it, you can probably do it if you can get the other parties to agree to it. I mean, it really is. It's you can buy votes. I mean, this is a time where it's legal to buy votes because, some impaired class is going to have to approve this, and you come up with creative ideas. In our case, we put properties into a trust. Off they went.
Without attribution, I'll say that I've had bankruptcy lawyers tell me that if the bankruptcy code doesn't say you can't do it, that means you can try. So, right. And it does invite creative solutions because, things are really on the tip of a spear to figure out whether, you can broker compromise, you need to buy votes, get the impaired class on board, create alignment between parties. It's a very interesting and fast-paced process.
But at the same time, you still, all through that process, you've got to keep people focused on the day-to-day compliance. That's still there. So if you're an operating entity and you've got manufacturing operations, you still have got to comply with the laws. It's not you don't get to turn off the control equipment. You don't get to quit taking samples and keeping people on that. And that's a struggle. One of the most difficult things I did during my bankruptcy was go down to a plant, the one we were trying to abandon. It had been shut down, but we were thinking of restarting it before we filed. And I had explained to the employees that were there why I was working so hard in bankruptcy court to abandon the plant and take away their jobs. That's not a fun discussion, but it was a real credit to the employees of that plant. The plant never did reopen. We eventually ended up settling and demolishing it. They were faithfully executing their responsibilities, making sure the plant site was safe, meeting compliance obligations and such. So I was really impressed by the employees of that particular site, that they remained dedicated to the very end, despite all the shenanigans and discussions going on in the bankruptcy court.
And Daniel, you started us on sort of the before bankruptcy, but there's a consequence to that whole dynamic after bankruptcy, right? Because you may have great leadership in the organization that helps you to take you through that. But inevitably, you need to kind of do a gut check on the back end of where are you from a compliance standpoint? What resources do you need to now change, going forward? Did people keep their eye on the ball on compliance and set the right tone through the process? Because now you're a going entity, and there are opportunities even in the new owner audit program. People don't often think of it in that circumstance because it's, it was old co and now it's new co and it has the same name. But the EPA's new owner audit program applies in those circumstances most of the time, where you can take that first 9-month period, get under an agreement and go through an audit process to make sure that you have, dotted your I's and crossed your T's, for purposes of going forward.
And in terms of dotting those I's and crossing those T's, Stephen has hammered this point that you've got to remain in compliance during the entirety of the bankruptcy, in compliance with environmental laws. And I had a question going into this podcast about how consent decrees are treated during bankruptcy for issues that, you've resolved with the government beforehand. Maybe there's a penalty you're still paying into, or you're complying with injunctive relief requirements that are specific to the consent decree as part of the settlement with the government for previous non-compliance. I think Stephen has sort of answered my question that those would all remain compliance obligations, that the source of law may be the consent decree and not particular citation in the Code of Federal Regulations. But that would be part of your compliance program during and after the bankruptcy. Do I have that right?
It's going to be very fact specific. I mean, that's the interesting thing about bankruptcy. As a general rule, you still have that consent decree, have to deal with it, but there may be aspects of it that you can get resolved and be done with. The things that are clearly going to pass through are the requirements for control equipment to be on and those types of things. But penalties and some of the other aspects, those type, if you will, more administrative things as opposed to actual impact on the environment, likely could be resolved. But that's one of the discussions you want to have with whatever agency you have the decree with, is to walk through all those requirements and see what you can or cannot get resolved or relief from, and then what needs to pass through and continue on. You could end up with an amended decree. You may end up with a bankruptcy resolution that sits on top of the decree or side by side with it. There's a lot of room for creativity, but as an in-house lawyer, you're going to be wanting to make sure that everybody remembers we've got to be in compliance and keep running the way we're supposed to under the rules.
I totally agree with Stephen that the penalty piece, there's at least some strong arguments that if you have a payment schedule and you're in year 2 of 5 years and you enter into a Chapter 11 process, you may not have to pay the back end of the penalty schedule. But if you're going to operate the plant going forward, you're going to have a hard time convincing EPA and the courts that you shouldn't have to abide by the injunctive relief provisions that are in the consent decree and apply to that facility. Another circumstance that arises and that I've been through is where you've been in a long-term negotiation with EPA and state agencies in relation to some allegations of non-compliance, and you're entering the bankruptcy process before having resolved the matter, right? And so you might take the position that, well, if the violations occurred prior to the bankruptcy, the new entity doesn't know any penalty or other obligation related to that. And so, how are we going to treat this an ongoing negotiation? If we sign a consent decree during the pendency of the bankruptcy, does the bankruptcy court have to approve the entry into the consent decree because you're not in the ordinary course of business? Or what happens if you enter the consent decree 30 days before you go into bankruptcy? Is that something that you shouldn't have done because it wasn't in the ordinary course of business? So all of those, any ongoing discussion that you have with the government about the resolution of environmental compliance liabilities is something that you're going to have to think about before, during, and after a Chapter 11 process for sure.
Absolutely.
That's fascinating. Any more thoughts on the during part before we roll out to the after and conclusion?
Well, during also, it depends on what your alleged violations of environmental law relate to, right? So many violations of environmental law are viewed as ongoing by the agencies, which give rise to a non-compliance each day, and a violation each day, and a penalty each day. So simply because the violation occurred prior to your Chapter 11 process doesn't necessarily wash away the entirety of the liability. And you may have an obligation to fix it or an obligation not to, to prevent the ongoing violation from the agency's point of view. And so you need to deal with that either during or after shortly after the bankruptcy process. If you don't have time during the bankruptcy process, is there an opportunity to get into an agreement with the government for a schedule for how long it will take you to come into compliance post bankruptcy, which may be something that you'd really want, because otherwise, you have the knowledge of a non-compliance in your operations that you're going to have to wrestle with post bankruptcy.
And when you look at, contaminated land, the government has been very open to setting up some kind of separate trust or fund to where it gets separated from the emerging organization. And therefore, but it has funding that's supposed to cover the cleanup, whatever those obligations were, but it can get separated from the company that exits out bankruptcy. So you want to take a look at that as an option. In the Lyondell bankruptcy, we put in 9 properties there. The GM bankruptcy is a great example. If you look at the Racer Trust that got set up, very successful program. I dealt with it some while I was at EPA, where they put a whole bunch of old GM plants and land into a trust, and with money that was part of the, exiting financing process, so that money got put in there. So there was real cash to clean up. And then that trust has been operating for a decade plus now, reinvigorating those properties, cleaning them up, getting them repurposed, sold out of the trust and such. It's a very successful program. And so there are ways to get rid of those properties that you no longer need for the ongoing operations as you emerge out, and put them in another part, another entity that then takes on that responsibility.
Stephen, have you seen any of those in relation to PFAS liabilities? I mean, that's sort of more on the horizon, right? That people wouldn't necessarily have known that those were liabilities of a company when it was in a Chapter 11 process, but certainly an emerging liability in the current times.
Mm-hmm. Yeah, I think that's going to be one of the great legal questions going forward. People knew about PFAS. Say if you filed, 5 years ago, PFAS was out there. Mm-hmm. The extent of it wasn't necessarily known. You could have assumed it was there. Did your notice of your bankruptcy give those other, PRPs or whoever they are notice? And did they have enough knowledge that they had a claim that they should have filed? And I think that's those who have gone through Chapter 11 have a bankruptcy defense will be arguing that, hey, you knew about whether it's, the climate change lawsuits and your GHG emissions, pre-petition or disposals that had PFAS in it. Were those claims resolved? I think it's going to be one of the fascinating debates and battles that go on in bankruptcy, courts going forward, because I believe that's the forum for when you have a defense. If you claim bankruptcy defense, sometimes it ends up back for the judge that you're trying to apply the relief you have and the discharge to it. So that'll be an interesting going forward.
But it's a more troubling circumstance for the judges, I imagine. So environmental law hates an orphan liability, right? So if you identify the liability, you set up a fund, you create a channeling injunction that says that, these types of claims go towards this fund, then you say, okay, everyone was on notice. There's a pot of money that was set aside of what was left of the debtor. And, that's the procedure. But if nothing was set up, no claims were made, can you then sort of credibly stand in front of the court and say, nope, everyone was on notice. Everyone who thought they had a claim should have come to the courthouse and lodge that claim so that we could have dealt with it through the bankruptcy process. I think that sounds like a harder circumstance for sure.
It definitely is a more difficult argument, but one that will definitely be made as if the cleanup costs are extensive.
Yeah, I hadn't thought about it in the context of climate change either, but certainly that argument will be made. We will see it.
We've been talking about what to do as you emerge from bankruptcy and other considerations there. And we've talked about the importance of notice on the front end of the bankruptcy to make sure you're including all possible claimants that may have an environmental claim against the company. And we talked about new owner audits emerging from bankruptcy to ensure you're taking full advantage of that policy's ability to help you diagnose your compliance status and enter into any sort of corrective actions. Any other considerations on the tail end and on the exit from bankruptcy before we go, gentlemen?
Once again, I'll go to my go-to discussion, making sure the resources are there to maintain compliance once you're out. As you put together your exit plan and such, ensuring that the capital is there for future construction that about, that requiring to put on various controls or changes you need to make to your operations. You need to think about the exit that you can operate in compliance, not only on day 1, but day 30, month 30, that it is set up for success, and ensuring that that has been thought through the process. Because if you go too streamlined and too thin coming out, you just may walk yourself into non-compliance problems very quickly. So it's very important that you think about that as you're doing that final structure, that there are the resources there for the operating side of the business to operate in compliance and the known future compliance obligations that they're staring at.
I think the one thing that I would want to have covered in our conversation that we didn't is to say Mid-Atlantic, right? If you are entering a bankruptcy process, or you think you may be entering a bankruptcy process, and you're asked to design a strategy to bring the company through to help it achieve its objectives, or if you're on the back end and you're new to a company that's been through a bankruptcy process, reading the Mid-Atlantic decision and some of its progeny can really help you get oriented quickly, because you need to understand how the courts have thought about environmental liabilities in the context of bankruptcies. You'll want to understand what the ability the debtor has to abandon property that is burdensome or of inconsequential value in the absence of a Mid-Atlantic situation. And I think if you have those basic parameters, then you can start to help map out a strategy for the company to use the bankruptcy process to give it the best fresh start that you can, right? Because your ultimate goal is to give the company a fresh start that gives it long-term viability. And that means understanding what are your liabilities, how can you use the tools of the bankruptcy process to manage those liabilities in ways that are, contemplated by the bankruptcy courts. So reading the Mid-Atlantic decision and understanding how it impacts the liabilities that you have really can help you shape the right strategy going forward.
Absolutely. And then you need to, as you're out, you need to preserve your defense. You need to assert it so that you don't end up losing it. My Superfund practice changed from, sending PRP negotiations and allocations and talking to the government to writing letters, should have filed a claim.
Yep.
Or, gee, you did file a claim. I guess you forgot. Here's a copy of it. Please go away. So it was a very different Superfund practice for the next several years.
Yeah. Well, I think that, Jason, you may have inadvertently started the Environmental Law Monitor Case Reading Club. So we're all going to go. We'll include a citation for the case in the show notes.
I'll put another one out there for your listeners. You should read You should read the Formosa opinion in Louisiana on EJ for permitting, because that's going to be a big deal.
That was a couple of weeks ago. Jason, can you give our listeners, if they haven't read it, I know it's a pretty sprawling opinion, but what's the high level summary?
Well, a Louisiana state court judge has determined that the LDEQ improperly issued an air permit for a new ethylene oxide plant on the basis of environmental justice and Louisiana state constitutional considerations. And that is a very impactful opinion for those seeking permits for new plants and the role that the judiciary could play on the basis of environmental justice or state constitutional considerations. I would expect that decision to be appealed. But if you're monitoring, these issues, and if you're someone who's listening to a podcast like this, I imagine these are things that you,
that's right,
are trying to stay abreast of. And I would recommend that one to the folks out there listening.
Yeah, when I read that, there were a couple of facts in there that I'm curious about, the underlying, just how, if they're true, that they're kind of interesting. But back to something you said earlier, Jason, about, orphan claims, and whatever you're designing, whatever you're thinking about trying to do, you've got to step back and just, does this make sense? Is the environment being taken care of? Mm-hmm. Is the community? Are the compliance obligations? You need to always have that pragmatic, just step back, and does it look like there's a solution for all the problems that have been identified? And if you're leaving something out there that is just being ignored, that's going to be problematic. Whether it's talking about bankruptcy settlement or permitting, again, in the world of EJ, you need to be thinking about that. So I often told young engineers when they come and do their calculations, I had one tell me one time that we released 15 million pounds. I said, you realize that's the capacity for the cracker for the entire day. Yeah, you might want, before you turn in those numbers, lock up your desk, go outside the door and look at the real world and see if it makes any sense. And if it doesn't, then something's not right. There's got to be a practical aspect and resolution of things to think about.
As creative as you might be in the bankruptcy process, you still have to enter back into the real world. You don't want to be off in la la land.
You have a license to operate, right? And if your vision is that you're going to operate the plant going forward, you have to maintain a relationship with the community in which you operate. That's a key stakeholder. So if you're plotting the long-term viability that provides you a fresh start, you have to figure out, just as Stephen had to go to a plant and communicate to people how to keep their eye on the ball, you need to have a communications plan that aligns with what you're doing from a strategy standpoint so that the community understands the bankruptcy process in appropriate ways and that, they have confidence that the plant is being appropriately run and safely run. And your workforce believes that because they're going out, they live in that same community. But all of that's important. And it is a difficult process to navigate, as Stephen sort of outlined at the outset, that you're constrained on resources, you're personally distracted because you think, I don't know what this means for my own future. And you have to, at that moment, exhibit a different type of leadership inside the organization to help guide it through. It's a challenging time. And some people do it tremendously well.
Yeah, I mean, think about the general public's view of a bankruptcy. Well, bankruptcy, they think deadbeat. But you got a bankrupt entity, you're going to keep running this chemical plant? What's going on? So having that communication plan, that talking to your neighbors, talking to your employees and such, if you are planning to be reorganizing, you're not disappearing, and that there are resources available, you have to have those practical discussions and contacts with those folks to give them confidence that it's okay for you to continue to operate in our community. You're going to be responsible and such. So it's important. That's why, your relationship with those around your plant are critical. We talk about Chapter 11 before, during, and after. And having that open dialogue with them and letting them know what you're doing and what you're doing to make sure that you are a good neighbor.
All right. I think that's a great place to wrap up, Stephen. We're not just interested in going through bankruptcy and getting that fresh start, but doing that as efficiently and as thoughtfully and as excellently as possible. So we'll leave it there. Thank you, Stephen. Thank you, Jason, for spending some time on the monitor. Everyone stay tuned. Be sure to subscribe. We'll have a lot of interesting content coming your way. Talk to you soon. That's it for us today at the Environmental Law Monitor. Big thanks to our guests, as well as Dorn, Julia, and Emily, and the rest of our production team who helped to make our podcast possible. And of course, you, our listeners. We'll talk to you soon.